Prior to the 1990 reapportionment, there was a challenge after the case that Chris talked about, challenging the multi-member districts again. And that was all fashioned and set up by the Democrat-controlled state election board in a way where it made it very hard for those that were defendants in the case, of which I was one, to rely on any state assistance for defense costs. And just a little story, we were sued, and when I say we, Paul Manweiler, John Ruckelshaus, and myself, that were the members of District 49. And we were going to retain Bill Evans to represent us. And so we went over to then Bose, McKinney, and Evans. I say we, well, Ruckelshaus was new, so he didn't go. Manweiler was supposed to go with me, and I waited in the lobby for about a half an hour, and he never showed. And I called him on
his calendar an hour later.
Well, I called him on his cell phone, and he was out in Colorado skiing. So I engaged Bose McKinney, to represent the three of us, thinking that somehow our fees would end up being paid by the state. And I wasn't too worried when that first bill came in, about $20,000. And then the next month, it had the red past due stamp on it, and it was up to 40. And we tried to persuade the Speaker of the House to pay that in sort of a spirit of comedy, that it was the right thing to do. But no, it was so partisan, so political, that bill got up to like 80 plus. And finally, then it was only through going to the Legislative Council, and which is a bipartisan body, that people, one Democrat in particular, Bob Hellman, a lawyer from Terre Haute, said, "I'm not going to let anybody stay hanging out," even though he was a Democrat. And that's when our fees got paid. But that was $80,000 for just a little skirmish in the district court, not to mention going to the Supreme Court. So the answer is yes, we did consider it, but no, we did not pursue it because we just didn't have the funds to do it, and thought those monies would be much better spent campaigning than litigating.
If I may say, I do want to let you know that was Speaker Mike Phillips that did that, as opposed to me. I was much kinder. One thing that, Justice, you said on that I think was interesting, just to let you know, when this bill passed in 91 and in 01, we're talking redistricting, because we couldn't agree. So reapportionment, of course, is the federal seat, so we had a commission, a 5-member commission, and it's the House that does it. There's the Speaker appoints 2, the Minority Leader appoints 2, and the Governor appoints 1. So I got to sit on both commissions, the first time by appointment of Evan Bayh, and the second time I was Speaker, and it was 3 Democrats, 2 Republicans. So we voted, we met, we had a hearing, and we passed the congressional map as written by the House both times. What was interesting for the state legislative seats, to talk about politics entering in, and this goes to where when the justice said that it's about protecting the 150 people in. Do understand that the bill that passed, drawing the maps both times, it was a Democrat map from the House with a Republican map from the Senate. And the Democrats in the House voted for the bill, while the Republicans voted against it. You went to the other chamber, the Republicans voted for the bill, and the Democrats over there voted against it. So my best friend during reapportionment was then Senator Bob Garton. John Keeler and former Speaker Manweiler's best friend was the Senate Minority Leader. And so that was a very interesting take. And in 91, the only way we could pass it was to put it in the state budget, which was, I think there's something in the rules that says about single subject matter and things standing on its own merit, but it passed in the budget bill. We didn't do that in 01, but we did in 1991. And so you have the incumbents in both chambers of opposite parties playing footsies with each other. Would that be a fair thing to say, John?
Oh, very fair, and just another example of, if there wasn't for self-interest, there wouldn't be any at all.
A comment on multi-member districts, by the way. The elections prior to 1980 redistricting operated on a basis of having at-large districts in entire counties. Marion County elected 15 representatives at large. So whoever carried Marion County got 15-0 advantage over the rest of the state, which was impossible to overcome in the 60s and 70s. If you had a 15-0 Marion County party, you had that party would control the House and typically the Senate as well, if you had the same thing happen in 2 elections. But the effect of that was to create a much louder voice in the Marion County, in the state legislature for Marion County, because assuming that the caucus of the county delegation held together within the larger party caucus, and 15 votes out of the majority party vote was a tremendous advantage. And the result of that was a lot of Marion County favorable legislation that came out of those days from both parties. The Democrats created the convention center, and the Republicans created Unigov. I mean, a lot of major things got done. But there was a problem with that 15-0. The 1974 election taught the Republicans that the lesson they had learned in '65 as well. This wasn't a permanent Republican majority, it was just a permanent Marion County majority. And so they took care of that in 1980 by splitting up the 15 into 5 3-member districts, each with 1 core Democratic district of 3 members and 4 satellite districts. It's a classic of cracking and packing the Democrats into 1 central district and cracking. In Fort Wayne, they created 2 3-member districts that divided Allen County right down the middle and split the Democrat seats 6-0 in favor of the Republicans. So that's a cracking, and then the packing in Marion County were classic examples. And they managed to keep an 18-3 Republican advantage essentially forever through the next decades.
Yeah, the only thing I think I could add to what Justice Bohm said, I agree that the 15 members really benefited Marion County, but so did the 5 3-member districts. Marion County had much more influence as a county in those days than it does today, and as a result of that, you look around and a lot of what we take for granted was the result of that.
Yeah, I didn't mean to suggest that the 12-3 did preserve that advantage.
I'll let that comment about Marion County not getting anything, since I'm probably the only person here that lives south of US 40 and not from Marion County, but it's an interesting take.
If I may say quickly, 2 points. One, that plan came to the U.S. Supreme Court in 1971. And basically this conversation was in front of the justices, and the argument that the court upheld the plan. And they came to Whitcomb versus Chavis, if you know the case, 71, 72, around there somewhere. The point is, the court said, look, if you're losing because, if they're drawing that district, because the argument was Democrats are losing, African Americans are losing in Marion County. And the argument to the court, Justice White was, who wrote the famous/infamous, depending on how you view the case, Washington versus Davis intent case. He said, look, if it's drawing this map in order for African Americans to lose, and that's what's happening, then of course the 14th Amendment it's implicated. If Democrats are losing because they're Democrats, they're just losing elections, right? That is aside to, which is interesting as I think about that case, when I hear this conversation, the idea that Marion County is getting more, I usually teach it as the court is kind of trying to figure out what to do here, and it's a really hard thing to do, which we're going to get to in the second session. But the court, this plan, as the court tried to wrestle with it, it couldn't figure it out. Interestingly, the next case, a case out of Texas, same case, multi-member districts, history of discrimination in Texas, which the court did not find in Indiana, or didn't cite to it. The court struck down similar plans on a racial basis under the 14th Amendment, canceling out the African American vote, said the U.S. Supreme Court. Justice White also writing that opinion. And we'll get to those. I hope that's going to come up in the second panel. I suspect these things will come up. But the second quick point is, as I hear about drawing districts and what we do and how we do it, and who does it, the one thought that keeps coming through my head, the one thing I keep thinking about is constituents. We're drawing lines, but we're not always thinking about who we're drawing lines for. Maybe, I mean, I heard self-interest, and of course it's not a criticism. I don't view it as a thing that we ought to criticize, but rather that's a fact. And it puts a lot of weight. I used to think when I was I'm down in Bloomington, and so when I first got there, we used to have a competitive district, the 9th Congressional. It was really stressful. And I used to think, man, I wish that I had a safe district. But I think what I meant, I don't think I know, what I meant was I want a safe district for me, so that now it's not stressful anymore. But our member of Congress, we've never met him. And again, that's not a criticism, that's actually a fact. So who are we drawing these district lines for? And does it make sense for legislatures to do it? That was my prior question. I have my doubts. In fact, I don't have
about
doubts.
5 minutes left on this panel, and we'll take a break. I had a question, and feel free to respond to this one as well, but before our members of the General Assembly have to leave, was redistricting an art or a science? Do you remember it as one way or another?
It's definitely both. The computer makes it a science. The art comes in getting the member to take maybe a seat that they're not as enamored with. Just to be real candid, I mean, it's turned into a science. You can look at the state Senate, where in 1990, the Democrats went into that election, I think it was 28 to 22, 28 Republicans. Frank O'Bannon was the lieutenant governor. He'd break a tie. The Democrats' goal was to get to 26 seats or 25. They got to 24. Since the election in 1990, I don't know if you know it, the Democrats have never increased their number. I mean, they're down to 9. They've stayed the same or dropped, stayed the same or dropped. Now, I think that this isn't meant to be a prediction. They may go up this time, but it's the first time they've increased in 10 years. But one thing I want you all to know, when the numbers were close like that in the House, I spent, whether I was the minority leader and Paul Manweiler and John Keeler, John was Paul's right-hand man, or whether when Mike Phillips was Speaker and I was the majority leader, because the numbers were close, I probably spent more time talking with John and Speaker Manweiler or John and Minority Leader Manweiler than we probably did other people in our caucus. The advantage of the close numbers for the citizens is it causes both parties, I mean, you work together every day. You had to even agree when we were going to adjourn early on and when we would come back. But it forced us to have a dialogue, and that's the one thing that is, I think, missing now. We spend a lot of time together. I have great respect for John and Paul. There were differences, trust me, there were major differences many times, but it forced us to work together. And I think that's the one thing that happens when you've got a lopsided control of either party. It would be the same. My party never had the lopsided control. But even when we had control, we knew that we had to normally always have Republican votes. And that caused a lot of cooperation and compromise, which I don't think is a bad word.
And I agree 100% with John, and I just added further proof of that. I mean, during this period, I mean, there were 2 50-50 ties in the House, first time in the state's history, and just how close those districts ended up making the legislature.
Any final thoughts or questions? Otherwise, I think we're due for 5-10 minute break. 5-minute break.
There's a question.
Oh, we have questions from the audience.
Anybody other than the legislature the power to draw districts, if I understood what you said. And recently, there was a representative from Hamilton County, I think his name is Tor, who's been introducing the bills to create an independent method commission to redistrict. Right. and he's gotten a little bit of support, but it's not enough to get anything passed. Is it your position that that bill is unconstitutional, and because it would have the legislature delegate to an independent body the responsibility for?
John, I think that's an open question. I don't know the answer to it. I mean, does the legislature have the right to delegate that function? I mean, it'll be something, I think, for the Indiana Supreme Court to decide if that ever does happen. But I will say this, just my personal take is, on this issue, is there's sort of a yin-yang effect. I mean, one chamber or one party can often try and advance, if you consider that to be a reform, but on the other hand, the other chamber, the other party is laying back. I don't think any party really wants to take that next step.
John, I was on that redistricting commission and as an appointee of Speaker Bosma, by the way, who knows my rather outspoken views on this subject. The bill that came out of that commission called for the commission to propose it to the legislature, and by statute required that the procedure for the legislature to do was just give it an up or down vote, yes or no, with no material amendments. So it complied with the requirement of the Constitution that, quote, the General Assembly shall do but it has to. They'd have a vote up or down, yeah. And if they voted it down, it would likely have ended up in the courts then, which was the idea of having an undesirable consequence that the legislature really didn't want as a consequence of their failing to act.
Thank you for the question. Let's take our 5-minute break and we'll reconvene.